Hi, welcome back. In this session, we are going to discuss about strikes and lockouts. That is with respect to Industrial Disputes Act 1947. So, Section 2, subclause Q of the Industrial Disputes Act defines a strike. The purpose of a strike by employees is to coerce the employer to concede to their demands. It is an antithesis of lockout. While lockout is a weapon for the employer, strike is a weapon for the employees. In England, various definitions have been attempted by the courts. The most accepted definition in England is expounded by J. Hannon as it is a simultaneous cessation of work on the part of the workman. So this is the most commonly accepted definition of strike, that it is a simultaneous cessation of work on the part of the workman. According to Oxford Dictionary, it means concerted cessation of work on the part of a body of workers. The Encyclopedia for Social Science defines it as a concerted suspension of work by a body of employees. The strike is a weapon used by the workman as a last resort in the process of collective bargaining. Section 2 subclause Q defines strike. It is 1. A cessation of work, and that is by a group of men, a workmen. Third, that is done under a common understanding or concerted refusal to work, and it must be in an industry. Then the strikers must be acting in combination. And the sixth one, the object of the strike must be related to employment or non-employment or the terms of employment or with the conditions of labor of the workman. So the definition of strike under section 2 subclause Q can be dissected into 6 parts. That is, the first, a cessation of work; 2, by a group of workmen; 3, under a common understanding or concerted refusal to work; 4, it must be an industry; 5, the strikers must be acting in combination; and 6th, the object of the strike must be related to employment or non-employment or the terms of employment or with conditions of labor of the workman. Strike means the stoppage of work by a body of workmen acting in concert with a view to bringing pressure upon the employer. The workmen must be employed in the industry. In Indian Iron and Steel Company versus Workman, that is 1960. In Indian Iron and Steel Company versus Workman 1960, the Supreme Court ruled that mere cessation of work does not by itself constitute a strike unless there is a requisite of intention. So intention plays a big role with respect to strike. Mere cessation is not a strike. Now, in Patiala Cement Company's case, that is in 1967, Patiala Cement Company case 1967. Here the Supreme Court held that the period of strike is immaterial. In the case of cessation of work, even for half an hour is amounted to strike. So the period of strike is immaterial. That was held in Patiala Cement Company's case. The Supreme Court in Northbrook Jute Company Limited versus their workman, Northbrook Jute Company Limited versus their workman 1960. The Supreme Court in this case held that when the workmen are not bound to do a particular work, refusal to do that work does not amount to a strike, despite the fact that refusal is concerted or under a common understanding. So, a refusal to work becomes a strike only if the workman is bound to do that particular work. Else, refusal to do a work does not amount to strike, no matter the common understanding or the intention or the concertedness. Now, another case, that is Standard Vacuum Oil Company Madras versus Gunasheel and MG. That is Standard Vacuum Oil Company Madras versus Gunasheel MG 1954. The workers of the company wanted to celebrate the May Day. They requested the employer to declare that day as a holiday. The employees were ready to compensate the loss of work by working on a Sunday. The company rejected the suggestion and refused to declare the May Day as a holiday. On the company's failure to declare May Day as a holiday, the workers applied for casual leave. So the question was whether this procedure resulted in a strike. The full bench held that there was cessation of work or concerted refusal to work, and the action of the employees to apply for casual leave did amount to strike. So that was held in Standard Vacuum Oil Company Madras versus Gunashilan MG. Now, in Mangaram versus Labour Appellate Tribunal 1956. Mangaram versus Labour Appellate Tribunal 1956. In this case, the workmen did not commence the work for some time after lifting their token and punching their cards. This amounted to strike. Then National Textile Workers Union versus Sri Meenakshi Mills, that is 1955. National Textile Workers Union versus Sri Meenakshi Mills 1955. Refusal of workers to resume work on account of sudden death of a worker acting in concert amounted to strike. So here the refusal of work was due to sudden death of a worker, and this also amounted to strike. Now in Buckingham versus and Carnatic Company Limited versus workers. So this is an important case which we discussed during the evolution or the objectives of Industrial Dispute Act. The Buckingham case, where it was referred to as Binney and Company. So Buckingham and Carnatic Company Limited versus workers of the workers of the Buckingham and Carnatic Company Limited. Here the Supreme Court ruled cessation of work may be for a short duration. Now the facts of this case. This is one of the important case law that comes under various heads throughout the Industrial Dispute Act. So towards the fact of this case, that on 1st November, the night shift operators of a unit of the mill stopped work. Some of them stopped their work at 4 p.m. and some others at 5 p.m. The stoppage ended at 8 p.m. in both departments. The strike ended completely by 10 p.m. The reasons for the strike was the management's expression of its inability to comply with the request of the workers to declare the forenoon of 1st November 1948 a holiday for solar eclipse. The Supreme Court pointed out that it could not be disputed that there was a cessation of work by a body of persons employed in the mill, and they were acting in combination, and their refusal to go back to work was concerted. So it amounted to strike. Now classification of strike. We have majorly or generally we have 6 classes of strike excluding illegal strike. So without including the illegal strike, we have 6 classes of strike, that is in general. The first one is general strike. A general strike is one where the workmen join together for a common cause and stay away from work. And the second one is token strike. It is also a kind of general strike. It is for a day or a few hours. The token strike is intended to draw attention of the employer to any issue. The third is a go slow strike. Go slow is not an ordinary strike. It is a misconduct on the part of the employees to resort to go slow strike. Here there is no cessation of work, but there is a slowdown. The purpose is to reduce the production. Go slow strike is not a strike within the meaning of the act, but a serious misconduct on the part of the employees. So Das Gupta, Justice of the Supreme Court, observed in Bharat Sugar Mills Limited versus Jai Singh, that is Bharat Sugar Mills Limited versus Jai Singh 1961. In this case, Justice Das Gupta of the Supreme Court observed that go slow has always been considered as a serious type of misconduct. So it was also observed by the Supreme Court that it is a serious misconduct, though it doesn't come under strike as defined in the Industrial Disputes Act, because there is no cessation of work. With respect to Industrial Disputes Act, the definition of strike, the first element is the cessation of work. In go slow strike, there is no cessation of work, so it is not a strike under the Industrial Disputes Act, but it is a serious misconduct on the part of the employees. Now, the fourth one is sympathetic strike. It is intended to extend moral support to the striking workmen. They have no demand of their own. It is a strike within the meaning of the act. So, in Kambalingam versus Indian Metallurgical Corporation Madras 1964, in Kambalingam versus Indian Metallurgical Corporation Madras, the Supreme Court observed that when the workers in concert absented themselves out of sympathy to some cause wholly unrelated to their employment, or even in regard to the conditions of employment of other workers in service under another management, such absence could not be held to be strike. The reason attributable was that essential element of the intention to use it against the management is conspicuously absent, and under such circumstance the management may take disciplinary action against their absence on the ground of breach of conditions of service. So, if a group of people is going for a strike to support some other group, not against the management, that is, there is a group of A and a group B, and the group B is under one management and group A is under different management. So, group B is on strike, but in order to support their cause, even though it is not related to any members of group A, if the group A members goes on a strike against their management, that cannot be called a strike, but the management of group A can take disciplinary action against their strike for the absence on the ground of breach of condition of service. So that is with sympathetic strike, and that was discussed clearly in Kambalingam versus Indian Metallurgical Corporation Madras 1964. Now, the fifth type of strike is hunger strike. It will amount to strike within the meaning of the act. In Piprite Sugar Mills case, 1957, certain employees of the mill resorted to hunger strike at the residence of the MD. The court held that the concerted action amounted to strike. Now, the sixth one, the last category we are going to discuss with respect to strike other than illegal strike, is work to rule. It is not a strike because there is no stoppage of work at all. Pen down strike will amount to strike. Rules relating to strike. Section 23 of the Industrial Dispute Act lays down certain rules relating to the lawful strike. They are the following. The first one, if the dispute is referred before a conciliation officer, strike is prohibited in any industrial establishment during its pendency and 7 days after the decision. The second one, if it is referred to the tribunal, strike is prohibited during the pendency and 2 months after the decision. The third, if it is referred to arbitration, the above rule is applicable. The fourth one, if it is covered by a settlement or award, strike is prohibited during the period covered by the settlement or the award. The object of these provisions is to secure industrial peace. So, with us, 4 rules are laid down and it is discussed under section 23 of Industrial Disputes Act. Now, in Bellarpur Collieries Company versus Salim Merchant, that is 1966. Bellarpur Collieries Company versus Salim Merchant. Here, Regional Labour Commissioner used his good office to arrive at some settlement, but the matter in dispute at the time of the strike was not covered by the settlement. It was held that the strike can be resorted to. Now, a strike is not a fundamental right, and that was discussed in Kameshwar Prasad versus State of Bihar. Kameshwar Prasad versus State of Bihar 1962. It was held that a strike is not a fundamental right. The effect of an illegal strike is that the employer can take disciplinary action against the workman. If a strike is illegal, the party guilty of the illegality is liable to punishment. Even in case of illegal strikes, a distinction has been attempted to be made as the first illegal but justifiable strike, illegal and unjustified. So earlier we discussed that sympathetic strike will not be considered a strike and disciplinary action can be against such strike. So it can be considered as one form of illegal but justified strike. So even when a strike is illegal, it can be classified as illegal but justified or illegal and unjustified. How can a strike which is illegal be at the same time justified? It is said that a strike may be technically illegal, but if a demand is justifiable, it is illegal but justified. If the strike is illegal and the demand is also illegal, followed by violence, it is called illegal and unjustified. So that is the two categories of illegal strike. Now, on the other hand, if the strike is illegal but resorted in a peace manner, then the demand is reasonable, it is called illegal but justified. Whereas if the strike is illegal but followed by violence, destruction of the property, and the demand is also not reasonable, the strike becomes illegal and unjustified. In Crompton versus the Workman 1978, Crompton versus the Workman 1978, it was held that in order to entitle the workman to wages for the period of the strike should be legal as well as justified. Now, in Indian General Navigation and Railway Company Limited versus their workman, Indian General Navigation and Railway Company Limited versus their workman 1960. In this case, the Supreme Court held that the strike is illegal. In Punjab National Bank versus Workman, that is 1982, Punjab National Bank versus Workman 1982, it was ruled that the right to strike is recognized by implication. In Bata Shoe Company Private Limited versus Ganguly, that is, the Supreme Court observed that participation in an illegal strike may not be necessarily punished with dismissal. Now, illegal strike. If any strike is resorted in violation of the above rules, such a strike is called illegal strike. That is with respect to section 23 of the Industrial Dispute Act. So if there is any strike in violation of the rules as prescribed in section 23 of Industrial Disputes Act, the strike is illegal strike. So every strike is not illegal. It becomes illegal only when it is violative of the statutory provisions. Now, according to section 25, no person shall knowingly spend any money in furtherance of an illegal strike. The word knowingly shows the mens rea of the person who spends money for the illegal strike. Breach of provision of section 22 or 23 of the Industrial Disputes Act attracts penal liability under section 26. So, any breach of the provisions of section 22 or 23 attracts penal liability, and penal liability is discussed under section 26 of Industrial Disputes Act. Therefore, in order to hold a person liable, two things must be proved by the prosecution. The first, that the strike took place in a concern which is public utility service within the meaning of section 2 subclause N of Industrial Disputes Act. So, the concern should come under public utility service as defined in section 2 subclause N of Industrial Disputes Act. And the second condition is that the strike was in breach of contract of service of the striking workman. So the strike must be in breach of contract of service. Now, in Madras Courts Limited versus Inspector of Factories Madurai, in Madura Courts Limited, Madura Courts Limited versus Inspector of Factories Madurai, the workmen went on strike without serving a notice under section 22. They claimed wages for national holiday which fell in the strike period. The Supreme Court held that they were not entitled to wages because they have themselves brought about the situation by going on a strike without giving notice, whereby the management was deprived of their right to take work from them. So, and the punishment, the penal liability is discussed under section 26 of Industrial Disputes Act. Section 26 prescribes punishment for illegal strike. It is fine of rupees 50 for 1 month's imprisonment or both. So it can be fine of 50 rupees or 1 month imprisonment or both. According to section 22 subclause 3, notice of lockout is not necessary when there is a strike. Notice must be served in the form prescribed. Illegal lockout, that is discussed in section 24. Illegal lockout is discussed in section 24. Any lockout resorted in violation of the above rules is called illegal lockout. No person shall finance for an illegal lockout. In Hamida Match Manufacturing Limited versus State of Bhopal, that is in Hamida Match Manufacturing Limited versus State of Bhopal, the management of the company of the factory notified that it had decided to close down the factory from the date mentioned due to incurring of heavy losses for the last 3 years. It was due to competition, non-availability and high rate of raw materials, levy of certain duties on import of raw materials, etc. The court observed that action intended to be taken was closure and not a lockout, and therefore the notice was one of closure and not lockout. So that was held in Hamida Match Manufacturing Limited versus State of Bhopal, that is 1954 case law. Now, prohibition of lockout. The prohibition contained in section 22 subclause 2. Section 22 subclause 2 against a lockout by the employer are similar to those against strike by workmen. In case of lockout, the prosecution has to establish the lockout is in public utility service. For lockout, a notice under section 22 subclause 2 is necessary. Therefore, a lockout without notice, except where such a notice is expressly dispensed with, is illegal under section 24 of the Act. So, and this was discussed in Tata Iron and Steel Company versus Workmen 1972. Tata Iron and Steel Company versus Workmen 1972. In this case, it was discussed that for a lockout, a notice under section 22 subclause 2 is necessary, but it is not necessary if it is expressly dispensed with as prescribed in the provisions of the Act, and if it is not in the exception and the notice is not given, that becomes a illegal lockout as under section 24. Then in Bellarpur Collieries Company versus Salim M. Merchant 1967. In Bellarpur Collieries versus Salim M. Merchant 1967. The Regional Labour Commissioner used his good office to arrive at some settlement. He did not act according to the provision of the Act dealing with the conciliation proceeding. The matter in the dispute at the time of the strike was not covered by the settlement, and therefore section 23 subclause C was held to have no application in the present case. Now, prohibition of financial aid to illegal strikes and lockouts. No person shall knowingly spend or apply money in direct furtherance or support of any illegal strike or lockout. The spending or applying of money on legal strike or lockout is not prohibited. Now, penalty for giving financial aid to illegal strikes and lockout. So, this penalty is discussed under section 28. So, section 28, of the Act provides that any person who knowingly expends or applies any money in direct furtherance or support of any illegal strike or lockout shall be punishable with imprisonment up to 6 months or with fine up to 1000 rupees or with both. So earlier we discussed that illegal strike is punishable under section 26, and later we discussed if there is a illegal lockout, it is punishable under section 24, and the penalty for giving financial aid to illegal strikes and lockout is discussed in section 28. So under section 28, the liability may be imprisonment up to 6 months or fine up to 1000 or with both. Now penalties for illegal strikes or lockout. Section 26 to 29. Section 26 to 29 of the Industrial Dispute Act provides penalties for illegal strikes and lockout. Please note, section 24 is regarding the penalty, is the liability where the notice is not served in the respect of strike as well as lockout. So that becomes illegal under section 24. That is not a penalty, but it becomes illegal under section 24. So penalties are discussed from sections 26 to 29. Penalties is discussed under section 26 to 29. Now, section 26 to 29 of Industrial Disputes Act provides penalties for illegal strikes and lockouts. The penal provision in this regard are as under. Section 26 subclause 1 provides that any workman who commences, continues or otherwise acts in furtherance of a strike which is illegal under this act shall be punishable with imprisonment for a term which may extend to 1 month or with fine which may extend to 50 rupees or both. Now section 26 subclause 2 provides that any employer who commences, continues or otherwise acts in furtherance of a lockout which is illegal under this act shall be punishable with imprisonment for a term which may extend to 1 month or with fine which may extend to 1000 rupees or with both. So these are the two penalties, section 26 subclause 1 and section 26 subclause 2. Once again, penalties for illegal strikes or lockouts is discussed from section 26 to 29. Now, difference between lockout and retrenchment. So 4 differences can be discussed. That is, first one, lockout is temporary whereas retrenchment is more or less permanent. Second, in lockout the relationship of the employer is only suspended, whereas in retrenchment such a relationship is relinquished. In lockout the motive is to coerce the workman, whereas the motive for retrenchment is to dispense with the surplus labor. Lockout is due to and during an industrial dispute, whereas in the case of retrenchment, there is no such dispute. So that is with the end of this session with respect to strike, different types of strike and illegal strike. Thank you for listening. Thank you for your support. Like, comment and subscribe. Don't forget to click that bell icon so that you get an update when I upload my next podcast or a video. Thank you. Take care and have a nice day.